Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, this is the second video in a 5-part series I'm doing on how to defend debt collection lawsuits. And in this video, we're going to show you how to get your case dismissed by asking the court to compel private arbitration. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll be notified each and every week and every day this week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about arbitration, and maybe kind of in a broader sense. If you're just watching this video, you might want to check the playlist that I am created in relation to this. This is going to be part of one of a 5-part video series that deals with defending debt collection lawsuits. The first one was on how to draft the answer to avoid a default judgment and get that submitted to the court. Well, in this one, we're going to talk about how to file a motion to dismiss your case and ask the court to compel what's called private arbitration. We're going to talk about what it is, why you'd want to do it, and when you should file that motion with the court. So let's talk about the first thing about what private arbitration is. So most legal disputes are dealt with through the legal system, through the court system. They file a lawsuit, you know, the debt buyer, the debt collector, whoever it is, they filed the lawsuit against you in the court. They then served you. Then you are in this period where you have to file a response. So that's how most debt collection cases go. But there are private companies that offer dispute resolution services like arbitration. And that's essentially what arbitration is the privatization of the court process. And there are these companies out there, the American Arbitration Association, another one's called JAMS, and they offer private arbitration services for a fee. Now, you may ask yourself, why would you want to go through a private arbitrator if it costs a bunch of money? It's because in some cases it can be much more efficient and can happen a lot more quickly. If you're dealing with a debt collection lawsuit, one thing you're going to realize is that in most states, these things take forever. In the state of Arizona, where I practice law, even cases held in our justice courts, which deal with disputes under $10,000, it can take a year or more for a case to be resolved. If the amount is more in dispute in Arizona in the Superior Court, it can take up to 2 years to actually get a case to go to trial. So some parties in just litigation in general will opt for private arbitration because it can happen more quickly, even though it can be more expensive. Now, how that relates to debt collection lawsuits. In credit card agreements, when you sign up for a credit card, they mail you the terms and conditions of that particular credit card. In most credit card agreements, there is an arbitration clause. Now, what this arbitration clause says, amongst other things, when you look for it, you'll find it in this big fine print section. But it states that either party, if there's a dispute between you and your credit card lender, either one of you can invoke this arbitration clause and ask that the matter be submitted to private arbitration. Now, the debt collectors will never do this. We'll talk about why here in just a minute. But it can be to your advantage if you invoke this clause and ask the courts to push it to private arbitration. So let's talk about why you would want to do this. If you file a motion with the court, and typically it's called a motion to compel private arbitration, if the court agrees with you, they'll dismiss the lawsuit and require the parties to go over and handle this through the private arbitration process. Now, the debt buyer, the creditor, whoever's suing you, they don't want to do this. Let me tell you why. It's very expensive. That's the first reason. It's very expensive to do this. I'm updating this video for 2022, so I pulled the new fee schedules for the American Arbitration Association. If the party's elected to go through there, you as the consumer are going to have to pay a filing fee of $200. And that sounds like a lot, but that's just the tip of the iceberg compared to what the debt collector is going to have to pay. The debt collector also has to pay $200. Actually, there's a $300 with the American Arbitration Association. They also have to pay a case management fee of $1,400. They have to pay a hearing fee, like if there's kind of like a court hearing or a trial, of $500. And then they have to pay the arbitrator, the person who's acting as kind of the judge in the case, $2,500 for every day that the trial goes on. So you pay $200, and in AAA, the debt collector is going to pay at least $300 for the filing fee, $1,400 for the case management fee, $500 for the hearing fee, and $2,500 to the arbitrator for every day that they're in the hearing. So they're going to spend thousands of dollars. you start to see real quick why this doesn't make sense and why they don't want to be there, because a lot of the debt collection lawsuits are for under $10,000. A lot of them are for under $5,000. And so if you're getting sued for $5,000, they're not going to want to go here, because they're going to have to pay out upfront $5,000 even to just have the arbitration company handle it. JAMS is similar. JAMS has a filing fee there's an administrative fee of $1,750 that the collector has to pay. You have to pay a filing fee of $250, so it's a little bit more expensive. And then there's an hourly rate for the arbitrator. I can tell you most attorneys and arbitrators charge between $300 and $500 per hour. So you're going to see this gets very, very expensive. It doesn't make sense, and that's one of the big reasons they don't want to do arbitration and will many times dismiss the case if the court requires the parties to go through private arbitration. The second reason the debt collectors don't want to do this is most debt collection lawsuits are filed on huge scale. The law firms have relatively few attorneys, and they file thousands of cases. It's an automated process, and they file these cases, and most of them go to a default judgment, and they can have paralegals and other staff deal with them. But if you have the matter pushed to arbitration, you're kind of throwing a big wrench into their machine. They're not sure what to do with it. Most of their attorneys have not dealt with the arbitration process, and so they run into a situation where all of a sudden it's super inefficient time-wise for them to deal with this. So it's kind of a double whammy for the debt collector. One, it costs a fortune for them to do it, and two, it's super inconvenient, and it's not a forum that they're used to litigating in. So because of those two reasons, often when you file a motion to dismiss and compel private arbitration, the courts will follow through. They'll do that and require the parties to participate that, and you get the case dismissed. Let's talk about when you want to file this motion. The reason why I put this video second in this 5-part series is because a good time to do it is, instead of filing an answer, you file a motion to dismiss and compel private arbitration. So you get served with the lawsuit. In most states you have 20 days, 30 days, whatever it says in your summons to file your answer. Instead of filing an answer, like we talked about in the last video, you can actually file a motion to dismiss and compel private arbitration, letting the court know, hey, this case is subject to arbitration, and I don't think that we should be fighting this in this forum. Now, you may be asking yourself, how do I know if my account had an arbitration clause? A great place to find out is at the Consumer Financial Protection Bureau's website. This is a government agency, and they keep a database of all terms and conditions of all credit cards, literally all of them. You can go there, search for your particular card, and you'll be able to download a PDF of it and look for that arbitration clause in there. So the first part of the case where you can do it is just right at the very beginning. If the court, for some reason, to deny your motion, they would then give you an opportunity still to file your answer, so you're not going to run any risk of having any type of default entered against you. That being said, if you've already filed the answer and you're well into your case, most arbitration clauses allow you to try to invoke arbitration at any time before trial starts. So even if you're several months into your case and you're like, you know what, let's deal with this another way, you can then file a motion to compel private arbitration and dismiss the case. So I hope that that's helpful. I'm going to put a link, I have it down in the notes to this. I do have an online tutorial with a template that shows you how to do this and goes into a lot more detail. This is a very effective strategy. Of all the approaches that I put out there, I get the most feedback on this, that people are very successful in getting their cases dismissed. Again, if you need specific legal advice and you're in the state of Arizona, I'm happy to meet with you in my office. I'll put a link down there as well. If you're not in Arizona, I highly recommend you contact an attorney who's licensed in your state and seek out specific legal advice in your case. Thanks for watching today.